Good morning, ladies and gentlemen. I am Claudia Robinson, and I'm the judge that is presiding over Magistrate Court this morning. Momentarily, we're going to go ahead and get started. I'm going to go ahead and give you some brief explanations as to what's going to happen, procedurally what this hearing is for, and then we'll try to get you out of here as quickly as possible so that you can go back to have lunch and everything else. So, at Magistrates, this is a non-adversarial hearing, so this is just to make findings of probable cause. For those of you that have been provisionally appointed to the Public Defender's Office by virtue of filling out an affidavit of indigency, you will have the public defenders at the jail and in the courtroom speaking on your behalf. The state is also present. They're going to go ahead and make some, they're going to give me some information. Then for the most part, a bond will be set in the hearing, and then you'll be on your way. As I mentioned, this is non-adversarial. I'm going to ask that you not talk about the facts of the case, because anything you say can and will be used against you. So please do not make any admissions or talk about the facts of the case. So with that being said, Kimberly Hyatt.
Any priors?
Good morning, Your Honor. Ms. Hyatt's here at Maine.
Good morning, Mr. Romero. How are you?
I'm doing pretty well. Thank you for asking.
All right, Ms. Hyatt, good morning. How are you?
Fine.
All right, Ms. Hyatt, you have been charged with touching or striking a battery as a domestic violence and possession of cannabis as 20 grams. Anybody want to be heard on probable cause? All right. So as far as I do find probable cause for the charge of domestic violence and possession of cannabis 20 grams or less. As far as bond is concerned, for the domestic violence, anybody want to be heard on that?
Yes, Your Honor. But I'll let the state go first as far as to verify to see if Ms. Hyatt has any priors.
Okay. Ms. Hyatt has no prior. State, what is your recommendation for the bond?
Your Honor, the state would just recommend a $1,500 bond on count one, not seeking any modification on two, and no victim contact.
She has no priors? Domestic
Judge.
violence.
No, Judge.
No priors at all?
No.
Oh,
Judge, in speaking with Ms. Hyatt, she's been residing in South Florida for over 10 years. She is currently employed. She works at Subway. She's been working. She just got the job. She's been working for them for about 1 month. She's making $8.05 an hour. She's also going to school. She goes to school online. She's trying to pursue her high school diploma. Before that, she was attending Carroll City High School. She is 21 years old. This alleged incident happened with her boyfriend. I did advise her, since it's a domestic situation, most likely there's going to be a no contact order. She is aware she will be residing in a separate location. She'll be living with her mother, who resides in Miami. As the state did verify, she has no prior contact. Your Honor, considering her strong ties to the community, her lack of financial resources, she has no money in the bank, no property, we'd ask you to consider an ROR on Ms. Hyatt's behalf.
Pre-trial, did you, you don't interview the domestic violence, correct?
Interview them, Your Honor. We don't recommend them due to the nature of the offense.
Okay. Did you have an opportunity to interview Ms. Hyatt?
She was interviewed, Your Honor.
All right. So here's what we're going to do with Ms. Hyatt. As far as count one, the bond will be set at $1,000. Or if pretrial is able to confirm the address that she would be staying at in Miami-Dade, I will allow her to go on pretrial with an ankle monitor. I will order that she have no contact victim with Sukhu Sanjay, which means, Ms. Hyatt, and I'm sure Mr. Romero will explain to you further, that if you have any contact with Mr. Sukhu Sanjay, you would be violating those terms of pretrial, and since there is no contact, you're looking at possibly getting even charged with those contacts. Understood? Is that a yes, ma'am?
Yes, Your Honor.
Yes.
Okay. I'm also going to order, if she has any guns or anything like that, that she surrender those as well.
Your Honor, will the court consider, I don't think she has a prior record, the GPS aspect of it. We appreciate the court placing her on pretrial release pending verification. In light of the fact that she has no prior contact with the legal system, will the court place her on standard pretrial release with the no contact order?
I'm going to put her on the pretrial with the electronic, and I'll allow for the, once you get more information on her behalf, then you can go ahead and revisit it with the division judge.
Okay, Your Honor, seeing if that's the case, if you're gonna place her on the GPS monitor, you just put on place her on the GPS. The GPS monitor, if she has no verifiable address, she won't.
Do you work?
You don't have
Would you say, okay.
We weren't, Judge, we weren't able to hear anything.
You got a step in front
It's
of
recall that she lives with her boyfriend, saying there's no contact. If she's
Your
going
account
to her
card
mom's house, we have to verify that she lives there. And we can't verify her address, say, if mom says she cannot come back here, she has nowhere else to go, then she's gonna stay.
Wouldn't she?
Well, no, the judge is signing either $1,000 bond or the free trial. Right. Let me explain to Ms. Hyatt what was said, because I don't think she heard everything, Judge. Thank you very much, Judge. We appreciate it. Okay. Miss Bianca McGill, come on up, please.
You told her that was going to bond us?
Anybody want to be heard on probable cause?
Yes, Judge. Both of her boyfriend arrested. The arresting officer was able to release her. In the case, there were no independent witnesses. I would argue that there's no probable cause for battery for him or her.
All right, I do find that there was a dispute that occurred. At the very least, it is mutual combat, but that would be fair. I do find that there was probable cause for some sort of a fight and some sort of domestic dispute, including a battery. So that argument will be denied. That will, however, the fact that it is a mutual combat situation will, however, affect the bond amount paid.
And, Your Honor, she has no record. I'll leave the bond in the court's discretion. I would just ask that a no contact order be issued.
Okay. Ms. McGill, Mr. Romero?
Yes, Judge, thank you. In speaking with Ms. McGill, she's been residing in South Florida for 2 years. She relocated from Philly and moved down here. Her family, her mother, her brothers, they all relocated down here to Broward County. They live in Hallandale, Florida. She currently resides with her boyfriend. At this point, she's not working. She's looking for employment. She has no property. She only has $200 in the bank. Judge, this is her first arrest ever. She is a registered voter. We'd be asking you to consider an ROR on Ms. McGill's behalf.
All right, Ms. McGill, I'm going to go ahead and ROR you on this charge. And I'm going to order that there be no contact with the victim, Angelo Nicholas. You cannot have any contact with Mr. Nicholas. There is going to be a mutual no contact order with Mr. Nicholas on behalf of Ms. McGill. So you cannot have any contact with your boyfriend. You cannot go back to your boyfriend's house. You have to find somewhere else to live. I don't know what the situation is. Do you have somewhere else to live, Ms. McGill?
Yes.
All right. You need to go back to where it is the alternative that you're going to live at. Because if you have any contact with Mr. Nicholas, you're going to be in trouble because you're going to be violating your terms of pretrial release. Understood?
Judge, in speaking with Ms. McGill right now, she understands the no contact. I've advised her that she can't have any sort of contact with her boyfriend. My understanding is her belongings are at the location, at the residence. Could she go one time accompanied with law enforcement to retrieve her belongings?
Yes. With law enforcement, she can go ahead and this is very routine. They're going to go ahead and stand by, but you need to call law enforcement to let them know, Ms. McGill, okay?
Thank you very much.
Thank you.
Richmond Bontemps.
Richmond Bontemps?
Any probable cause on this?
No probable cause argument, Judge.
Mr. Bontemps, you're charged with striking as a domestic violence. I find no probable cause for that charge. You're also charged with resisting officer without violence. I find probable cause for that charge as well. As far as bond is concerned, on count one, Mr. Ritter.
Your Honor, Mr. Bontemps had a possession of marijuana from 2015. As far as bond, I would just be seeking a $1,500 bond on count 1, not seeking any modification on 2, and no victim contact.
All right, Mr. Romero.
Judge, in speaking with Mr. Bontemps, he's been residing in South Florida his whole life here. He's 21 years old. He is currently employed. He works at D&E Consultant in customer service. He's been employed with that company for about 4 months. He's making $10 an hour. Financially, though, his resources are limited. He has no money in the bank, no property. He does not. He has a separate place to reside other than with the alleged victim. Judge, we'd be asking you to set a reasonable bond as to Mr. Bontemps.
Where's he going to reside? Where are you going to reside, Mr. Bontemps?
With my mother,
Where does she live?
Margate.
Okay, in Margate? All right. What's that address?
I don't have it at this time. Because just moved there.
All right, so I'm going to set the bond at $1,000. For count 1. Count 2 will be $100. And I'm going to order that you have no contact with Miss Gina Perino. You understand that, Mr. Bontemps?
Yes, ma'am.
Okay, you cannot go back to that house. If for whatever reason you need to go back to that house, if you heard, as you heard me explain to somebody previously, you can go back to that house with law enforcement. They can help you. They can stand by while you get some of your belongings. But you need to stay with your mom during the pendency of this hearing, of this case. You understand that?
Yes, ma'am.
All right. So,
Judge, we have one other request. Would you sign a photo order allowing us to photograph Mr. Bontemps' injuries?
yes, I'll sign that.
Thank you very much. Appreciate it.
Mr.
Okay,
Gonzalez.
you're done.
Angelo Nicholas.
Mr. Nicholas? Mr. Nicholas here present?
All right, Mr. Nicholas is the co-defendant to Ms. McGill, and I'm assuming that you have the same argument, Mr. Gonzalez?
Correct, Judge.
All right, that argument is adopted, and that argument is previously overruled in the sense that I do believe that there was some sort of mutual domestic combat, domestic violence. But as a result, that will certainly affect the bond amount. I find probable cause for the domestic violence. Mr. Linder?
Again, Your Honor, I have no objection. Whatever bond release conditions the court deems appropriate, I would ask for no contact order. Would also just advise the court, Mr. Nicholas, his priors include 2008 grand theft, trespass 04, grand theft and unlawful use of false name ID 02, and I'm showing in the system that Mr. Nicholas has an outstanding warrant out of Dade County from 2010 for a petty theft. Did he?
Okay.
Oh, and I'm also showing, I'm sorry, Judge, a grand theft out of California from 07, and he had an arrest in Philadelphia in 2000 for false reports to law enforcement, and it also appears that there is an outstanding warrant on that case from 2000.
What would your recommendation be?
Your Honor, based on the two outstanding warrants, and I understand this is a mutual combatant situation, but to ensure his future appearance in court, I would ask for a $1,000 bond and no victim contact.
$1,000.
Mr. Romero?
Judge, $1,000 in this situation seems reasonable.
All right, $1,000 bond. No contact with the victim, Miss McGill. That means, Mr. Nicholas, that it doesn't matter, you cannot contact her, you cannot have somebody else contact her. She cannot contact you either, there is a no contact, there's a mutual no contact order. So just stay away from each other during the pendency of this proceeding. Although you may be traveling soon, a lot. All right?
That's just until everything is over, then we're allowed to communicate again?
Once those contacts are lifted, yes. Once those no contact orders are lifted.
Thank you, ma'am.
You're very welcome, sir. Good luck to you. Rory Suarez Murillas.
That's going to be a medical reset.
Rory, so, no, I believe it's a medical loan.
Okay, so reset it to tomorrow.
Yes, Judge.
Omar Masonette.
Mr. Mason, come on up, please.
All right, Mr. Mason, good morning. Your charge with count 1 is domestic violence, count 2 is resisting or obstructing without violence, which is a no charge, and count 3 is a capious for a misdemeanor in 1506074 TC 48, wherein your bond was set for $500. I find probable cause for that capious for
Do you have an attorney?
Not at this time.
Are you gonna hire your own?
failing to appear at a hearing. So that bond is set at $500, and the probable cause is filed for count 3. Count 1, anybody want to be heard? Probable cause.
Department?
Judge, I think there's enough for probable cause, but then she seems to have recanted and said that nothing happened. And the officer didn't observe any emergencies, although noting that she was uncooperative, so.
Arguments are noted, they are overruled. I find probable cause for the domestic violence charge.
don't see it.
As far as bond is concerned, Mr. Linder?
Just one moment, Your Honor. Is that still open?
Sure.
Your Honor, I'm showing Mr. Masonette has open charges out of Dade County from November of last year. 2 counts of battery on a law enforcement officer, resisting with violence, and DWLS, third or subsequent, based on the fact that he has an open charge and he's been alleged to commit an act of violence in this matter. I'd be asking for a $5,000 bond on count 1, no victim contact.
Mr. Romero?
Yes, Judge. And speaking of Mr. Mason Net, he's been residing in South Florida for the past 10 years. He's currently employed. He works at the port in receiving. He's been working there for the past 8 months. He makes approximately $12 an hour. Financially, Your Honor, he only has $200 in the bank. He owns no property. Your Honor, we'd be asking you to consider Mr. Masonette's financial resources, the strength of the case, as far as the victim seems like she's recanting, and determining a reasonable bond as to Mr. Masonette.
And I'm sorry, Your Honor, if I may. The only thing I would just want to note for the record, it appears in this matter that there was an independent witness. So I think that minimizes the impact of redaction by the alleged victim.
All right, where, okay, yes, I see that. That's all right. Where, if Mr. Masonette, if you post, if you're able to post this bond, where are you gonna stay? Because I'm gonna order a no contact victim with Sumi Andre. You cannot have any contact with her. You cannot go back to where you're staying. If you have any property back at that house, are you staying together? Do you live together?
I believe they do reside together, Judge.
Yeah. So you cannot stay there. If you need to retrieve any of your personal belongings, you can do so, but with the assistance of a police escort. But otherwise, where are you going to be staying, Mr. Masonette?
I stay in North Miami on Long.
I'm sorry?
I stay in North Miami.
With his mother, he's
North
going to
Miami
be
with
staying
your
in
mom?
North Miami.
Probation for anything?
Okay.
No.
And I'm bound to free trial.
No.
Thank you.
All right, so you understand that you cannot have any contact with the victim, and I'm going to order that you surrender any weapons if you have any of those weapons. And if you have any contact with the victim, that's just going to be causing you a little bit more trouble, because you're going to be possibly adding charges to your offense. You understand that?
Yes. David, I've been away. I've been overseas working.
So I'm going to set the bond at $4,000,
4,000, so 10% would be 400.
and count 2 is a no charge, and count 3 is up to $500. Thank you, sir.
Thank you, Judge.
You're welcome. Jordan Clark?
Mr. Clark, come on up, please.
All right, anybody want to be heard on probable cause?
No argument from defense.
All right. Mr. Clark, you're charged with touching or striking battery and daily violence. There's a probable cause for that charge. And as far as bond is concerned, Mr. Linder?
Your Honor, as far as the bond in this matter, I'm going to be asking for a $15,000 bond, no victim contact, pretrial release with a GPS monitor. One, Your Honor, our office had contact with the alleged victim in this matter and advised us that she suffered a 9-inch laceration as a result of the alleged violence in this matter. Additionally, Your Honor, Mr. Clark is currently out on bond for aggravated battery with a deadly weapon. It's alleged in that matter, June of last year, he struck a man in the head with a wooden stick that was attached with metal nails and sent the man to the hospital. As far as that matter, that'll be up to Your Honor whether you choose to revoke sua sponte or not. I'm not formally moving at this time. No further argument.
Mr. Romero?
Judge, and speaking of Mr. Clark, he's been residing in South Florida his whole life. He is 28 years old. He's currently working. He works for a cleaning service company. He's been working for them for the past year. He makes $10 an hour. He does not live with the alleged victim. He lives in West Park with his mother. He's been residing at that location for the past 2 years. Financially, he has no money in the bank, no property. We'd be asking you to set a reasonable bond as to count one, and we'd ask you to not revoke his release conditions on his open case and leave that for his division judge who knows Mr. Clark better, Your Honor.
I'm not going to revoke that bond. The state and it's not on the docket, so I'm not going to sua sponte revoke the bond on that other case. However, in this case, because of the propensity, I'm going to go ahead and set that bond at $20,000. And I'm going to order Mr. Clark to not have any contact, no contact whatsoever with the victim, Alicia Nashay Gilbert, not through a third person, not through any contact whatsoever. Surrender any and all weapons he may be having in his possession. And that's it.
Your Honor, as far as the state's request for GPS monitor,
Oh, did you request that as well?
yes.
All right, if he is able to place the bond for $20,000, I will put that condition as well for the GPS monitor.
Thank you, Judge.
You're very welcome. Eugene Caterno,
He's over at the North Broward Jail, Judge.
he's still a medical recess?
No, he's not. He's here.
Oh, okay. Mr. Caterno?
He's at the North Broward
Oh,
Jail, Judge.
okay, sorry.
Oh, Eugene Caterno? No, he's at North Broward.
Yeah, that's what I said.
Yep, North
Oh,
Broward.
North. Oh, sorry.
Hi,
But-
anybody
I
from North
apologize.
Broward?
Nobody-
I appreciate that, Mr. Upson. How are you, Mr. Caterno?
I'm doing pretty good
Okay.
after the operation.
Your Honor, may I just briefly go? Sir, I'm just going to discuss because everything here is being streamed online, and I want the whole world knowing about your medical condition. I'm
Yeah.
going to tell the judge what you told me, okay?
Okay.
Judge might go for sidebar briefly.
Sure, let me see if I can. All right, so we're back on the record with Mr. Caterno. All right, Mr. Caterno, so as far as probable cause, there's no argument as far as probable cause. I do find probable cause for the domestic violence charge. All right, now we're going to go ahead and hear argument on bond. Mr. Linder, any priors?
Your Honor, in 2011, he was arrested in Broward for domestic violence battery against the same alleged victim. That was dropped. He was arrested in 2004 in the state of Massachusetts for domestic violence, assault, and battery. I have no disposition. In one moment, Your Honor. I see arrest in the state of New Hampshire. Looks like 2001 and 2003 for criminal threatening and simple assault. Again, I have no dispositions, Your Honor. Another arrest for simple assault in 2005 with no disposition. Your Honor, based on his prior arrests for both involving domestic violence and just violence in nature, which, and even though he was not convicted or pled out to any of those cases, according to the Florida statute, the court can take those in consideration in this matter. I would be asking for a $2,500 bond, no victim contact.
All right, Mr. Trabzon?
Just briefly being heard on the issue of bond. He's a resident of Fort Lauderdale for 9 years. He's a retired truck driver. From his retirement, he gets about $11.50 a month. He does tell me he does have a place to stay separate and apart from his wife if the court ordered no contact. He does have family and friends here. In light of his medical condition, which I discussed with the court sidebar, and also note that even though the court can take into consideration arrests, the court can give way to however it wants regards to the prior domestic violence arrests. I didn't hear any criminal convictions in his past. In light of that, I'm asking the court to set a $1,500 bond in the case, no contact.
Mr. Caterno, how long have you been living in Broward County?
Approximately 9 years.
Do you have family up in New Hampshire and every?
Do I still have family in New Hampshire? Yes.
Okay, all right.
Yeah.
All right, Mr. Caterno, I'm going to order that you not have any contact with Miss Angela Martinez, which means that you cannot
Okay.
you cannot talk to her, you cannot reach out to her, you cannot have somebody else reach out to her on your behalf. I'm going to order that you surrender any and all weapons that you may have in your possession. If you need to go back to the house to get any of your personal, where are you going to be living if you're able to post bond?
Well, it'd be like near Deerfield, so I just have to go over there one time and pick up my stuff. you
Okay,
know.
and I'm going to advise you to go ahead and call for a police escort so that they can go
Right.
ahead and assist you with that so that you don't violate this no contact order. And where are
Thank
you going
you.
to be staying in Deerfield? With a friend, family? Who's there?
A friend I went to school with.
Okay. All right. I'm going to set the bond at $2,000 and I'm going to order that he have no contact victim with Miss Angela Martinez. All right, Mr. Paterno?
Okay, thank you.
Thank you very much, sir. Good luck to you. Camden Thompson?
Mr. Thompson, come on up, please. Yes, Camden.
Mr. Thompson? Any problem cause argument?
No probable cause, sir.
All right, Mr. Thompson, you're charged with aggravated battery, causing domestic violence, as far as bond is concerned, Mr. Linder.
Your Honor, Mr. Thompson has no priors. That being said, I'm going to be asking for a $5,000 bond, no victim contact. One, based on the level of violence alleged in this matter. Two, I'm concerned for, even with the no contact order, I'm concerned for the victim's future safety just based on the allegations, the amount of force and apparent rage that Mr. Thompson used in getting at the alleged victim who locked himself in a room. Allegedly, Mr. Thompson used enough force to break the locks off of the door, going through the door and attacking him with a piece of wood.
Mr. Romero?
Judge, I didn't hear, the audio is cutting out. Is there any way to put the microphone closer?
Mr. Linder?
Not at the,
I can't really move it any closer. It's going to be in my mouth.
oh, now I hear it. Now I'm fine. I'm fine. Thank you. Judge, in speaking with Mr. Thompson, he's been residing in South Florida his whole life. He is 31 years old. He's not working at this moment. He's looking for work. He was working at a restaurant called Ladies Be Island Dish. He was a cook, making $8 an hour. Financially, though, he has very limited resources. He has no money in bank, no property. Judge, we'd be asking you to set a $2,500 bond. He's going to hopefully pray that his family can come up with that amount in order to bond him out.
All right, well, let me ask you this, Mr. Thompson. This is your brother, the alleged victim, that I'm going to order that you have no victim contact with. You cannot contact your brother. I don't care if it's your brother's birthday. I don't care if it's your birthday. If there's a family picnic, you cannot have any contact with him. You cannot go to the picnic. You cannot have your mom contact him for you. You cannot have any contact with him. Where are you going to live? If you're able to post this bond, where are you going to live?
Burn house.
No, you can't go back to your house.
No, a friend's house. He really doesn't know. He's going to have to like get on the phone and speak to his friends and see who can possibly take him in, because he knows, I've explained it to him, if he has any sort of contact, then he'll be right back in here. So he's going to try and contact his friends, Your Honor.
All right.
Have a seat. Here. Over there, where you were.
All right, so I'm going to order there be no contact, as I explained, with Campton Thompson. And I'm going to I'll set the bond at $4,000. Thank you, sir. Angel Rivera? Any,
Mr. Angel Rivera?
No,
come on up,
Judge.
please.
No probable cause, All right.
all right. Mr. Rivera, you're charged with felony battery as a domestic violence. I do find probable cause for that charge. Mr. Linder?
Yes, Your Honor. Mr. Rivera, in 1998, had an attempted robbery with a firearm or deadly weapon and a DUI in 92. Just, if I could have one moment, I'm getting hits outside of Broward County. I'm not getting into that, it's too old. Yeah, I'm looking at Connecticut. Your Honor, out of the state of Connecticut, in 1998, I'm showing arrests for threatening, breach of the peace, violating a protective order, harassment, another arrest for violating a protective order, assault, another arrest for violating a protective order.
All of these in 1998? 1998 was not a good year for Mr.
Yeah, they were. The original threatening breach of the peace was 97, but everything else was 98. There's no dispositions on any of those offenses. I'm showing an arrest and date in 97 for child abuse and battery. Those charges were dropped. An arrest for aggravated battery in 86 in Alachua County, that was dropped. An arrest in 86 in Tampa for aggravated battery, that was dropped. Your Honor, based on his prior arrest, the allegations in this case, specifically an alleged threat to kill while in possession of a weapon, Your Honor, I'm going to be seeking a $25,000 bond, no victim contact, pretrial release with a GPS monitor.
Mr. Romero?
Judge, and speaking of Mr. Rivera, he is 66 years old. He's a United States Army veteran. He left the Army in 1997. Financially, though, he limited resources, only has $400 in the bank. He owns no property. He's been living in Hollywood. He lives with his 37-year-old son. Judge, we'd be asking you to set a reasonable bond.
What was the discharge of the Army? What was the discharge?
When was it? In
How was the
1997.
discharge? Was it a general discharge?
Honorable.
Honorable? Okay. So I guess he'll be
Major.
seeing, he may be eligible for Veterans Court, is that right? Or is this charge?
I think it has to go through an approval process. It may be, but I don't think it can automatically go in like a drug charge or.
Okay, all right. So, Mr. Rivera, you live with your mom?
Say again?
You live with your mom?
No, I do not live with my mom. My mother is deceased.
Okay, who does he live with, Mr. Romero?
I live.
He lives with his son, Your Honor, who's 37 years old
And your wife?
in Hollywood.
And your
I am
wife, the
divorced.
alleged victim, where does she live?
I did advise him, Judge, if you could read off the name of the alleged victim. I have advised him that he cannot have any sort of contact with the alleged victim, direct or indirect.
All right, so, Mr. Rivera, you cannot have any contact with your wife, Miss Leanji Rivera? So I guess you don't live together with your wife at the Cozy Camper Trailer Park?
Let me inquire.
That doesn't make sense. Now he lives on with his son?
Judge, Miss Liamji Rivera, my understanding is that's his girlfriend, but he advised me at the location, I believe it's a mobile home.
Motorhome.
Oh, motorhome. It's his place, and that she does not permanently live there. But I did advise him cannot have any contact with her. Many times I've advised
So
him.
does his brother live there too?
No, my understanding is what he's told me that his son also lives there,
Son.
off and on. Correct.
All right. Okay, so, all right, Mr. Rivera, I'm gonna order that you not have any contact whatsoever with Miss Rivera. Okay, you cannot have any it just so happens that your girlfriend has the same last name as you?
Does not. Can I speak?
All right, no.
I do
No,
not
don't
want you
hear it.
talking about the facts of the case.
All right, this is a little weird. I'm gonna order that you have no contact with Miss Rivera. Absolutely none, not even through a third person. And I'm gonna order that you not, if Miss Rivera is over at that trailer home located at 3651 West Commercial Boulevard, seeing as how it says that the probable cause affidavit says that she's your wife, then I'm gonna order that you cannot return to this location. And I'm gonna set the bond at $20,000 with, if you're able to set that bond, I'm gonna order that you be put on an ankle monitor. All right? Thank you very much, everybody. Laura Melendez.
Judge, could you sign an order having Mr. Rivera? He's advised me that he has several health conditions, diabetes, and high blood pressure. If he could be medically screened and given any appropriate medication.
Yes, I'll sign that order.
Thank you.
20,000.
Findings 4. Oh. Okay, on the thing? Oh. All right. You're very welcome. Laura Marie Melendez. All right, anybody want to be Mr. Afzal?
No probable cause argument, Judge.
All right, Ms. Melendez, I do find probable cause for count 1, DUI, as a first offense. Count 2 is DUI with property damage. I do find probable cause for that charge as well. And count 3, I find probable cause for DUI with the enhancement as it relates to you blowing over a .15. Anybody, Mr. Linder, would you like to be heard on
Your Honor, I wasn't going to be asking for any modification. The only additional release condition I would ask for is order not to, no intoxicants, no alcohol, Your Honor.
All right, Mr. Romero?
Judge, you're speaking with Melendez. I'm sorry. She's born and raised here in South Florida. She is a full-time student. She works. She goes to FIU. She's pursuing her accounting degree. She advised me she has 5 credits left until she graduates 5 classes left until she graduates. Her graduation expected date would be in summer. Your Honor, she lives with her grandmother. She helps take care of her grandmother. Her grandmother is retired. She doesn't drive also. Your Honor, we'd be asking you to consider an ROR on Ms. Melendez's behalf, considering she has no prior exposure to the criminal justice system and her strong ties to the community.
Recommended pretrial release, Your Honor, with random monthly testing and a drug/alcohol evaluation.
No. All right, Mr. Afzal, did you want to be heard on something?
No, I was just gonna let Mr. Romero know earlier that pretrial is being recommended. Yeah.
All right. I'll go with pretrial's recommendation. Do I still give her a monetary bond? No.
So she'll be released through standard pretrial,
Yes,
Judge?
ROR pretrial, yes. With the
Okay,
conditions as
by
set
when
forth.
does she...
Random testing. All right. So, Ms. Melendez, if you're released before 3 p.m. today, you have to go report to pretrial release today. If not, if you're released after, you have to report first thing in the morning. Okay?
Let me explain this. Okay, this is a map to pretrial. If you get released today before 3 p.m., you have to go to this place. It's across the street. This is a map. If it's after, you have to be there by tomorrow morning, okay? This is how you get to pretrial. Make sure you go to pretrial, else there's going to be a warrant for your arrest. Okay? Go back.
Danielle Terry?
Thank you, Judge.
Thank you, Mr. Romero.
Miss Terry? She's coming up, Judge?
All right, Ms. Terry, you are charged with trespass, failing to leave a property upon being ordered by the owner. I do find probable cause for that charge. The bond is set right now at $25. Mr. Romero?
Judge, in speaking with Ms. Terry, she advised me that she's never been arrested before. If the state can verify it, she does not have the means to bond out if you would consider an ROR.
Your Honor, she has no record. If Ms. Terry is inclined, the state's offer at this time would be a withholding court cost.
Does Ms. Terry want to resolve her case, Mr. Romero?
Let me ask her.
What? Where do you see that? It's 2016. Your Honor, it looks like she picked up a trespass in South Satellite about 10 days ago. It's still the same offer, but... Yeah, I know.
Judge, I believe she wants to accept the state's offer of a withholding and resolve it today.
All right, Ms. Terry, would you please raise your right hand, ma'am? Do you swear affirm the testimony you're about to give us the truth, the whole truth, and nothing but the truth so help you God?
Yes.
All right, you may put your hand down, ma'am. Ms. Terry, are you under the influence of any alcohol, medication, or drugs?
No.
Have you ever been treated for a mental illness?
No.
Can you read, write, and understand English?
Yes.
So you understand everything that's going on here today?
Yes.
All right. Ms. Terry, are you on probation or parole anywhere in the world?
No.
All right. Ms. Terry, at this time, you've been advised by your attorney, Mr. Romero, who's in the courtroom with you, and you wish to take the state's offer of a withhold of adjudication and court costs. Is that right?
Yes.
And you don't want to take this case to trial?
No.
All right. And you understand that if you're not a U.S. citizen, this will subject you to deportation. You understand that?
Yes.
All right, Ms. Terry, having said that, as to the charge of trespass, how do you plead, guilty or no contest?
No contest.
All right, I accept your plea. I find that you're fully voluntarily and intelligent. You may be right to find that you're competent to learn. I find that you know land this plea, or just the nature of the charges of the consequence plea. After reviewing the charging document, I find that there's sufficient facts to basis for your plea and sentence you according to the negotiated offer of a withhold of adjudication court costs. I'm going to give you 3 months to pay those court costs. If you need more time, you can contact my office at the South Satellite in room 214. All right?
Okay, so I'm being released today, correct?
Yes.
Thank you very much.
You're very welcome, Ms. Terry. Good luck to you.
Thank you.
Okay.
You have any more?
Michelle Culhane.
Ms. Colhane, come on up, please. Judge, in speaking with Ms. Colhane, she wishes to resolve her case. If Your Honor would offer her the withhold court cost, she'd be more than willing to accept it.
All right, I do find probable cause for the charge of trespass. State, you want to be heard on the offer?
No, that's the offer I make, Your Honor.
All right, Ms. Culhane, so you want to resolve your case? Please raise your right hand, ma'am. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, let me put your hand down. Are you under the influence of any alcohol, medication, or drugs?
What's that?
Are you under the influence of any alcohol, medication, or drugs right now?
No.
Have you ever been treated for a mental illness?
No.
Can you read, write, and understand English?
Yes.
Do you understand everything that's going on here today?
Yes.
All right. Upon speaking to your attorney, he's advised that you wish to resolve your case today and plead guilty or no contest to the charge of trespass and receiving withhold of adjudication and court costs. Is that right?
Yes.
All right. And are you on probation or parole anywhere in the world?
No.
Okay. And you understand that if you take the state's offer, if you're not a U.S. citizen, this will subject you to deportation. You understand that?
What was that?
You understand that if you're not a U.S. citizen, taking the state's offer will subject you to deportation. You understand that?
Yes.
Okay. And you don't want to take your case to trial?
No.
Okay. Ms. Culhane, as to the charge of trespass, how do you plead guilty or no contest?
No contest.
All right, I accept your plea from that you're fully voluntarily intelligent. We have the right to find that you're not criminally alert, find that you know nature is clear, and understand the nature of the charges, and the consequence of plea after reviewing the charging document, and that there's sufficient evidence to support plea, and sentence you according to that negotiated offer of withhold of adjudication and court costs. You get 3 months to pay your court costs. If you can't pay your court costs in 3 months, you can contact my office in room 214 in the South Satellite Courthouse, okay?
Okay.
Thank you, ma'am. Good luck.
So that means I go home today?
Yes.
Thank you.
You're very welcome. Trevonna Bowens?
So you only take it when you're in jail?
Judge, I've been informed Ms. Bowen's bonded.
Okay, all right, very good. Justinina?
She's here, President Maine.
All right, Ms. Bermudez? Anybody, Mr. Absol, do you want to be heard on?
Yes. Judge, this
The
is,
assault charge was a no charge, so the only thing that she's charged with is the possession of cocaine.
well, then, no.
Okay.
I'll leave it alone.
I find
I
probable
forgot.
cause for the possession of cocaine. The bond, the standard bond right now is set at $1,000. Mr. Linder?
One moment, Your Honor. Yeah, I believe both. Well, we'll get to it when we get to Ms. Perez's case.
Right.
One moment, Your Honor. I just...
It's just for the possession of cocaine, right?
Yes, I'm just checking to see. Okay. Yeah, she had an arrest last year. Aggravated battery, aggravated assault. I think it's the offense that was mentioned to in the report, Your Honor. It was dropped in November.
Any drug charges?
None that I see, Your Honor.
All right, Mr. Romero, you want to be heard on the $1,000 bond? I'm not inclined to change it.
Judge, nothing to add at this time.
Bond is left at $1,000.
Your Honor, we would be asking for a no contact order.
That there's no nexus to the possession of cannabis charge. That assault was no charge.
Well then, Your Honor, that's just says no charge for bond purposes. It's still an offense she was arrested for.
My understanding was that if it says no charge, she wasn't charged with it.
No.
Although she may have
No.
been arrested for it, she's not charged with it.
They're not requiring a bond.
She is charged at this point in time. I mean, whether the state files an information, that'll be determined at a later date. But the charges she is facing at this point in time are assault and possession of cocaine.
Judge, just for the record, the fact that she was no charged on count 1, I didn't make an argument because I didn't have an argument as to probable cause as to count 2. I just
Right,
want
no,
to put
I
that out
understand.
there.
All right, so, okay, I'm I'm gonna enter a no contact order. Ms. Bermudez, I'm gonna enter that you have no contact whatsoever with Anthony Perez. Do y'all live together?
Nope.
Okay, very good. So then it shouldn't be a problem. You cannot have any contact with Anthony Perez. Mr. Perez is gonna be up here in a little bit, and I'm gonna order that he have no contact with you as well. So during the pendency of this proceeding, of this case, you can have no contact with each other. You cannot ask your mom to contact him. You cannot ask friends to contact him on your behalf. And I'm going to order that you surrender any and all weapons that you have in your possession. And I'm going to place. My understanding was that since it says no charge, I didn't have to place the bond.
No, where it says there, that specifically only has to do with bond matters.
So do I have to put a bond on that charge?
No.
Oh,
No,
okay, very good.
NC bond is not required.
Okay, all right, very good.
Okay, that's it.
There you go.
That's all.
I'll do that up there.
Malcolm McFadden.
Mr. McFadden is coming up.
All right, Mr. McFadden, you're charged with a capias on case number 160075540 MM10A, where the bond was set at $500 by that division judge. Good thing is that you're going to go see that division judge on January 19, 2017 at 11 a.m., sir. Good luck to you. I can't disturb that capias. Thank you, sir.
January 19th at 11 a.m. You'll be seeing your judge, okay? Thank you.
Nicholas Navas.
Mr. Nava, come on up, please.
Mr. Absal.
I have no probable cause argument.
All right, Mr. Navas, I do find probable cause for the charge of petty theft as a first degree. That is a first degree misdemeanor. That's how it's charged. And the standard bond right now is set at $100. I'm not inclined to disturb it unless somebody.
I'm not making any requests.
All right.
Judge, if I didn't hear correctly, but if Mr. Navas has no prior record, Your Honor, we'd be asking you to consider an ROR.
He has a criminal record. It was just nothing that amounted to me seeking a bond increase.
Gotcha. Okay, then nothing to add at this time. The only thing we'd be asking for then, Judge, is a photo order for Mr. Navas.
All right, that order is granted, Mr. Navas, and the bond on count one is set at $100.
Thank you, Judge.
You're very welcome. Tony Carlisle. All right, Mr. Carlisle, you are being held on a capias for a misdemeanor case 150-2145 MO20A. The bond was set at $100 by the division judge.
It's a municipal ordinance case. The public defender's office doesn't represent.
Staying in a shelter right now.
Depending on the city, if it's out of the city of Fort Lauderdale, it would be Mr. Jara McLawrence. If it's Holly.
Case number correction is 160-2145. Sorry, go ahead.
If it's stemming out of the offense, if it's stemming out of the city of Fort Lauderdale, Mr. Lawrence would be the public defender. If it's Hollywood, right, any of the other counties.
Oh, Deerfield Beach.
I don't know if Mr. Shade handles those, but the issue is that I don't see a court date there, and if he doesn't have counsel, he doesn't have the benefit of somebody bringing him to court to resolve this open container. He could be sitting in there. I don't know how long.
Well, can I resolve it without the city attorney?
Yeah, and Mr. Carlisle is a friend of the court, Judge. He's advised me he's going to inquire and ask you if you could consider resolving it today for time served.
All right, yep. All right, Mr. Carlisle, have you please raise your right hand, sir? Do you swear
Yes,
affirm the
ma'am.
testimony you're about to give us the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, Mr. Carlisle, you can put your hand down. Sir, are you under the influence of any alcohol, medication, or drugs?
No, ma'am.
Have you ever been treated for a mental illness?
No, ma'am.
Can you read, write, and understand English?
Ma'am?
Can you read, write, and understand English?
Yes,
Do you
yes.
understand everything that's going on here today, sir?
Yes, ma'am.
All right, very good. Mr. Carlisle, at this time you've expressed an interest in resolving your case in case number 1600245 MO20A, wherein you're charged with open container. Is that right, sir?
Yes, ma'am.
All right.
Yes, ma'am.
Are you on probation or parole anywhere in the world, sir?
No, ma'am.
Okay. And you understand that by taking this offer, you this would remain as a municipal ordinance charge, a criminal charge on your record. Do you understand that?
Yes, ma'am.
Okay. Mr. Carlisle, you don't want to take your case to trial?
No, ma'am.
Okay. Mr. Carlisle, as to the charge of open container or municipal ordinance, how do you plead guilty or no contest?
No contest.
All right, I accept your plea. If that you fully voluntarily took the waiver rights of coverage upon your notify that you don't make choice and responding to the charges against you as free. After reviewing the charging document, I find that there's sufficient facts to basis for your plea. Sentence you accordingly to the court's offer withhold adjudication court costs and time served. All right, sir?
Okay. Yes, ma'am.
I'll give you 3 months to pay those court costs. If you have more time, you can let me know, okay?
Okay, ma'am.
Take care, sir. Dominique Negro.
Mr. Negro is here, present at Maine.
All right, Mr. Negro.
Negro.
Mr. Afzal, you want to be heard on Mr. Negro's behalf? No, today. Okay. On the resisting without for Mr. Negro?
No.
Okay. Mr. Negro, I find probable cause for the for count 2, resisting officer without violence. I'm not inclined to disturb that $100 bond unless the here for the state.
I'm not seeking any modification.
All right, Mr. Romero?
Judge, Mr. Nigro has requested me to ask this court if you would consider pretrial release. He has no sort of financial ability to post the bond of $100. He advised me that he lives in Fort Lauderdale at a house that he's obtained through Veterans Society. Your Honor, he'd be asking you for standard pretrial. He would report and abide by any conditions you give him. And he's United States Marine Corps veteran, served from 2011 through 2015.
Your Honor, he has a warrant out of Philadelphia from December 20th of last year for violating a court order. He also has pending charges out of Palm Beach, actually pending charges out of Palm Beach from December 7th of last year, possession of heroin and resisting without violence.
All right. I'm going to leave the bond at $100.
Thank you, Judge.
You're welcome. Jonathan Swasey?
Mr. Swasey, come on up, please.
All right, Mr. Swasey, you're being held on a capias for a traffic misdemeanor 1605440TC20A. Count is driving while license suspended. The bond was set at $500 by the division judge for failing to appear in court.
Yeah, I know.
Here you go, sir. Good luck to you.
Judge, Mr. Swasey is asking me if you would consider an ROR. I know another judge already predetermined this bond, but from what I normally don't ask, but what he advised me is he's now obtained a valid driver's license. If this state can verify that he has a valid driver's license, would you consider an ROR?
Let me see. I have this information. Oh. His license is going to be suspended again as of the 16th, the 19th, and the 19th of this month for failing to appear to 3 tickets. So albeit valid right now, it's valid pending those sanctions for those tickets.
I have to take it in though.
But at least, from what he's advised me,
He's had to take it in the Judge Victoria.
right. From what he's advised me, Your Honor, he's gone ahead and already taken care of some steps to try and clear up his driving record, and that's why he has a valid driver's license.
I mean, advanced driving school.
He is in driving school. I don't know if you could take that into consideration.
I'm glad that he's done some work on his license, but as you noted, the whole issue is that he doesn't go to court. And that's why he's here today, because he didn't go to court.
Sure. All right, I'll lower the bond to $250. All right, thank you.
Thank you.
Armando Duran Perez.
Mr. Duran Perez?
Mr. Perez.
Judge, we're going to need a Spanish interpreter for Mr. Duran Perez.
Okay. Right, we'll put Mr. Perez on a brief recall.
Yeah, but like after Friday.
Anthony Perez. Right, I know that Mr. Anthony Perez is the co-defendant.
Mr. Anthony Perez?
Miss Bermudez.
Ms. Bermudez?
Yeah.
Right. All right, Mr.
Judge, I would argue that he's a victim in the case. The other person was also charged with an assault numerous text messages where there were threats to kill Mr. Perez, and threatened to do bodily harm, which placed him in fear. In light of that, Judge, I would ask the court not to find probable cause against for the assault charge.
Well, Your Honor, I would argue, based on what Mr. Officer just said, the court should find probable cause for a second-degree felony, written threats to kill, under Florida statute 836.1, written threats to kill or do bodily injury. Any person who writes or composes and also sends or procures the sending of any letter, inscribed communication, or electronic communication, whether such letter or communication be signed or anonymous, to any person containing a threat to kill or do bodily injury to the person to whom such letter or communication is sent, or a threat to kill or do bodily injury to any member of the family of the person to whom such letter or communication is sent, commits a felony of the second degree.
All right, although he is charged with a second-degree misdemeanor right now, I'm gonna, over your objections, I'm gonna find probable cause for the charge of assault for the second-degree misdemeanor. As far as bond is concerned, Mr. Linder? Any priors?
Your Honor, the only thing I see is he was also arrested last year, felony battery, domestic violence by strangulation, depriving an officer of a weapon or communications device. Those charges were dropped. I believe Ms. Bermudez was the alleged victim of that case.
Mr. Romero?
Judge,
So
at
what's
this
your-
time,
I'm
nothing.
I'm sorry, what's your recommendation?
Your Honor, I would be asking, and even though it was based on a cocaine charge, I believe the total bond Ms. Bermudez received was appropriate. I would ask for a total bond of $1,000 for him also, no victim contact, just to ensure that there is no communication between the two of them.
Mr. Romero?
Judge Joe, at this time, the defense would have no objection to the standard bond, the $100. He's going to contact his mother. He's hoping his mother will go ahead and post his bond. I believe the co-arrestee was not required to post bond at all for this
For that charge, because that charge was a no charge, but she did have a bond of $1,000 for the possession of cocaine, which Mr. Linder, I'm not inclined to leave the bond as is right now. I'm just letting you know. So, I mean, Mr. Perez, I'm going to give you a bond in this case, but I'm also going to order that you not have any contact with Ms. Bermudez. None whatsoever.
I'm sorry to interrupt you. I actually wanted to get a restraining order on her as soon as I got
Listen, you can go ahead and seek those avenues, but I'm letting you know right now, she's got a no contact order for you, and you have a no contact order for her. So during the pendency, at the very least of this hearing, you cannot, of this case, you cannot have any contact whatsoever. You cannot contact your friends to contact her. You cannot contact your mom or her mom to contact her. Just no contact whatsoever. And I'm going to set the bond at $500, and if you are able to post the bond, sir, I'm going to order that you be put on electronic monitoring.
And Your Honor, we'd ask for possession of firearms.
I'm sorry to interrupt. I didn't catch
And no
what you said.
possession of any firearms. You're ordered to surrender any firearms or weapons that you may be in possession of.
Judge, will the court place him on pretrial release with the GPS without requiring a bond for the misdemeanor? He was also threatened by her. She was also arrested in past making threats towards him. It seems like they both were making threats of harm to each other.
Not at this time, but I'll allow you to revisit it with the division judge. David Inez?
Pre-trial release? Okay.
Yeah, and pre-trial. You're going to be on pre-trial. That's what she imposed.
Okay.
And the $500 bond. You have no contact whatsoever. If you do have contact, you'll be arrested.
Oh,
all right, go.
David Inez?
Sure. Mr. David Inez, come on up, please.
All right, Mr. Inez, you're being held on 2 counts. Count 1 is a capias on a misdemeanor. On case number 150-111-95-PC-28. That bond was set at $500. That was set by the division judge. And you're also being held on a violation of probation on misdemeanor 14048896-TC-28. That bond is set at $1,000. I'm not disturbing those bonds. I cannot. So good luck to you, Mr. Inez. Thank you.
Thank you, Judge.
Darwin Mingo?
Judge, may I go sidebar briefly? might go sidebar.
All right, back on Darwin Mingo, I'll provisionally appoint the Public Defender's Office to represent Mr. Mingo, and we'll reset him to tomorrow.
Well,
Roll over?
if we're transferring Judge Lerner Ryan, I don't think we have to bring him back here anymore.
Yes, the magistrate eventually.
You can,
He's not going to come back, Your Honor.
Your Honor can find, but pursuant to statute, Your Honor can find probable cause even without him being present. And if he's going to be transferred, it's just quicker to just send him through, and they'll bring him to Judge Lerner Ryan.
All right, I find probable cause for the charge of trespass on Mr. Mingo's case. I'll leave the bond at the standard right now, the set $25, and we'll transfer him. I'll set an order transferring over to mental health. Judge Lerner Ryan. Zane Thompson.
He's here at Maine.
All right, Mr. Thompson, welcome, sir.
How you doing, ma'am?
I'm doing very well, thank you for asking. How are you?
I'm doing fine.
All right.
I'm doing okay.
Considering the circumstances.
Considering the
right?
circumstances. All right, Mr. Thompson, you're being held on a violation of community control charge, case number 140075266CF10A. That bond is a no bond that was set by the division judge. I can't disturb that bond, but the good news is that you're going to go see your division judge on the 17th at 8:30 a.m., okay?
All right. The thing is, I saw that I've been to magistrate for this charge already.
Okay.
And
Yeah, you'll see the division judge on the 17th, so you'll get more information from them then, okay? Good luck to you, Mr. Thompson.
all right, ma'am. Thank you.
You're welcome, sir. James Gore?
Mr. Gore, come on up. James Gore. Judge, Mr. Gore declined the services of public defender. He's going to come up.
All right, Mr. Gore. All right, Mr. Gore, I'm going to advise you, please do not talk to me about the facts of the case. Mr. Gore, you're charged with count 1 is possession of methamphetamine. I do find probable cause for that charge. And right now, the bond is set at $1,000 for that charge. Mr. Linder, I'm not inclined to disturb your bond.
Your Honor, the one thing the court should be aware of, he is out on bond or release right now for possession of methamphetamine and drug paraphernalia.
All right. Mr. Gore, you know that you have a pending case for the same charge, so it's only a matter of time before the state possibly moves to revoke that pretrial release. But on this case, I'm gonna leave the bond at $1,000. All right, Mr. Gore? Good luck to you, sir.
I'm showing he's up.
Anthony Hampton?
Mr. Hampton, come on up, please.
All right, Mr. Hampton, Mr. Afzal, do you have a probable cause argument?
Judge.
All right, Mr. Hampton, count 1, you're charged with possession of cannabis, 20 grams or less. I find probable cause for that charge. And count 2 is a violation of probation or community control for felony case number 140132666CF10A. You're being held no bond on that case. I can't disturb that. Good thing is that you're going to go see the division judge on the 12th at 9 a.m. As it relates to count 1, I'm not inclined to disturb the $100 bond that is set right now.
And Your Honor, just to note for the record, because I believe this is an issue that has come up, I just want to advise the court on count 2. It does appear that Mr. Hampton would qualify as a violent offender of special concern.
Okay,
I'm not seeking any. Your Honor, I'm not seeking any kind of bond modifications. I'm just bringing it to the court's
Okay,
noted.
all right. So I'll leave the bond at $100 for count 1. Thank you.
I'll show you right here if you want to. If you want me to show you here.
Alexis Simon?
Mr. Yeah.
If you come up.
Oh, Judge, Mr. Simon's coming up. He declined the service of public defender.
All right, Mr. Simon, good morning.
Morning.
Sir, on count one, you're charged with grand theft. Mr. Afzal, do you have any argument on Mr. Simon for count one, grand theft? All right, I do find probable cause for count one for that grand theft, and count two is a parole violation, Mr. Simon, where you're being held no bond. I cannot disturb that bond, and I do find probable cause for that parole violation, as it was signed already by a judge. As to the bond set on count one is $1,000. Mr. Linder?
This is Mr. Simon. Your Honor, with the parole hold, I'm not going to be seeking.
All right, I'll leave the bond at $1,000 for count one. All right, Mr. Simon, good luck to you, sir.
Thank you.
You're very welcome. Christopher Shenard Davis.
Mr. Davis?
Welcome, Mr. Davis. Count one, you're charged with driving while license suspended. Any probable cause argument?
Judge, I have no probable cause argument.
All right, so I do find probable cause for driving while license suspended charge. The bond right now is set at $750 on that charge. Mr. Linder?
Your Honor, I'm fine with this $750 bond.
Mr. Romero?
Nothing to add from the defense.
Okay, very good. Bond is left at $750 on probable cause. Thank you very much, Mr. Davis. Good luck to you. Freddy Alberto Elias.
Judge, I need a warrant on this. I haven't read.
I'm sorry, who's this, Your Honor?
This is
Freddie
Elias.
Elias, page 12, Mr.
I'm
Lund.
going to be asking that this matter be moved to 1:30. A detective from Hollywood and the victim are going to be present in court at that time.
Okay, so we'll reset Mr. Elias' case to 1:30. And the state needed a copy of the warrant, so I'll go ahead. I'm sorry.
No, I've got a copy of the affidavit. Do you have a copy of the warrant or the affidavit?
He wanted a copy of the warrant.
Yeah, he want the affidavit.
All right, so you'll give him a copy?
Yes, I will.
Okay, perfect.
I'll provide a copy of the
All
court
right, so
also.
we'll reset Mr. Elias for... I need a statement.
Thank you, Judge. I just advised Mr. Elias he's on reset till 1:30 today.
Okay, perfect.
I can read it. This one's messed up. I was talking to this head of...
Thank you.
Judge, we do have the Spanish interpreter here.
Oh, perfect. Perfect. Mr. Armando Duran Perez. All right. Madam Interpreter, would you please raise your right hand? Do you swear affirm that the translation you are about to give from English to Spanish and from Spanish to English will be to the best of your abilities?
I do. Good morning,
right.
Your Honor. Solange Sands.
All right, very good. So now, Mr. Duran Perez, you have an interpreter present, and she's going to interpret on your behalf.
Señor Durán Pérez, tenemos una intérprete presente y ella le va a interpretar.
So please give her an opportunity to interpret what I'm saying to you and what you're going to be saying to me.
Así que por favor, dele la oportunidad de interpretar lo que yo le estoy diciendo a usted y que ella me interprete lo que usted va a decir a mí.
All right. So Mr.
Bien.
Mr. Duran Perez, you are being charged with trespass, failing to leave a property upon order by the owner. Mr. Afzal, do you have any probable cause argument?
Entonces, señor
No,
Durán
Judge, not
Pérez,
this
se le
one.
acusa de entrada ilegal y no salir de una propiedad después de que se lo pidió el dueño. Vamos a ver si hay suficientes pruebas.
All right, there, I do find probable cause for that charge. The standard bond right now is set at $25.
Decido que hay suficientes pruebas para ese cargo y hace una fianza normal, una fianza de $25.
State, would you like to be heard on this charge?
Your Honor,
¿El Estado tiene argumento?
as far as an offer, I'm unable to make an offer at this time. Based on these...
Thank you. En lo que tiene que ver con hacerle una oferta al señor, en este momento no puedo hacerle oferta.
Based on these allegations and other known recent events at this location, I really wouldn't be able to make an offer without having more communication with TSA.
Basado en las alegaciones y también otros incidentes recientes de ese lugar, no puedo hacer la oferta sin tener más información.
Judge, I understand with regards to the recent, there are no threats of violence or harm. I think that they charged him, I believe this is a trespass because he was intoxicated. They wouldn't let him on the flight.
En lo que tiene que ver con actividades recientes en el lugar, de acuerdo de la defensa, no se ve que el señor hizo ninguna amenaza ni violencia, solo que parece que estaba alcoholizado y por eso le han puesto un cargo de entrada ilegal. ¿Y el señor tiene antecedentes?
Your Honor, I'm not getting any hits in any of the databases. Nothing's coming up, period.
Mirando la computadora acá del tribunal, no sale ningún antecedente.
It does appear from the booking sheet that Mr. Duran Perez does reside out of state.
Ahora, lo que parece en el documento de arresto, parece que el señor Durán Pérez no vive en el estado.
All right, Mr. Romero, you want to be heard on the $25 bond? I'm not inclined to.
Judge, from what Mr. Duran Perez advised me, he's from Las Vegas. He came here for work purposes. He's a salesperson. He came down, there was a convention regarding bridal showers. That's what he's involved in. Judge, he has no sort of contact, anybody to try and contact to post his bond right now. We'd be asking you to consider an ROR.
El señor me ha contado que él está aquí por propósitos de trabajo. Él es un vendedor y estaba en una reunión de las fiestas que se le hacen para las novias. Entonces no tiene contactos aquí locales que le podrían pagar la fianza. Pedimos que lo dejen en libertad bajo palabra.
All right, I'm going to leave the bond at $25 since he is out of state. So it's respectfully denied.
Bueno, él no vive en el estado, así que dejo la fianza en $25. Respetuosamente niego ese pedido.
Madam Interpreter, would you like to make an announcement?
I'll be happy to, Your Honor. ¿Alguien más necesita los servicios del intérprete?
Do we have anybody else in any of the other jails?
They should be hearing you. So.
Okay. No, we're just going to require a Portuguese interpreter, Judge.
Portuguese? Do you speak Portuguese?
I called for one earlier. They're trying to work for the afternoon.
Okay.
If not, can get it this afternoon, tomorrow morning.
Okay. All right, very good. So, Madam
Yes,
Interpreter.
I was aware. They are looking for your Portuguese.
Yeah, I would ask reset it for the PM and see if we
Which is
could
the
get one.
Portuguese?
The main Hector, who's the Portuguese?
It is, ¿qué es su nombre?
Elio Lessa.
Yeah. ¿Qué?
Elio Lessa.
Elio Lessa?
Elio Lessa.
Page 14.
Page 14, I've been advised.
Yep. All right, we're going to go ahead and
Helio Lessa.
Yes. We'll reset him to 1:30 in hopes that we will have a Portuguese interpreter. However, as it relates to the Spanish interpreter that is still present, when she be released, nobody else needs the services of the Spanish interpreter? No? All right.
Nobody else here in Maine. Okay, 1:30. A la 1:30
All right,
van a
very
volver.
good. Thank you very much, Madam Interpreter. Have a good day.
My pleasure, Your Honor. Have a great day.
Christopher Parker.
Your Honor, before the court makes any determination, I'm going to concede. Upon reading the report, it looks like it was a misbook. There's really no allegation that he was armed. So I'm not seeking any kind of no bond hold for armed burglary.
Okay. So are you going to change the charge?
Your Honor, I'm going to ask the court if, unless the defense has any objection, a finding of PC for the lesser included a burg dwelling, and ultimately it'll be up to a case filer to make that determination. But
Yeah, but I can't find probable cause for the way that it's charged right now.
no, Your Honor, what you can do, and I don't know if Mr. Officer has any objections, we've done plenty of times in here. If the court finds probable cause for a different offense, you can basically write in on the findings, PC for Berg dwelling.
I have no objection to the court doing that, Judge. I was going to make the argument as to the arm aspect of it anyway, but I think there's sufficient probable cause for the Berg dwelling.
Okay, so where do I write that?
Basically,
Right underneath the charge, Your Honor, do not cross out count 2, because it's still in the system as that, for the jail purposes.
So just word when not the arm.
yeah, you can read
Right, just
that.
right underneath.
You just can't take it with you.
What is it, Mr. Lemon?
Berg dwelling, burglary of a dwelling, unoccupied. It just has to say Berg dwelling for what she's writing. The statute has all three, but she doesn't have to write that.
And I'm not finding probable cause for count 2. Okay. As to count 1, possession of burglary tools with intent to use, Mr. Upsall.
No argument, Judge.
All right, so I find probable cause for that charge as well. And the bond. Okay, so Mr. Linder, you want to be heard on bond?
1 moment, Your Honor.
Burg dwelling is a third degree misdemeanor, right?
Second degree felony.
Second degree felony?
Yes.
Sorry. Sorry. Second degree felony.
I don't know if I could just have 1 moment. Okay. Your Honor, in 2011, it appears it was on a direct file adult charges of robbery with a firearm. I guess it pled out on a YO. Mr. Parker was adjudicated delinquent, placed on probation based on his prior violent offense and the allegation of breaking into someone's home. I'm going to be asking for $1,000 on 1, $10,000 on 2, no victim contact.
I'm not finding anything on 2 because I found no probable cause. But 2, as it's been changed to the burglary burglary dwelling.
Yeah, that's what I'm at. I'm just asking for the $10,000 on for Berg dwelling on count 2.
Gotcha. And no victim contact.
Yes.
Okay. Mr.
Yes, Judge. And speaking of Mr. Parker, he's been residing in South Florida his whole life. He is 21 years old. He is currently employed. He works at the Urban League of Broward County as an intern, getting paid $8.05 an hour. He's been doing that for about 4 months. It's part of his responsibilities. He files papers. He plans on pursuing his education at Broward College. He's getting right now all his paperwork in order. There's a $60 filing fee that he saved up and that he's attempting to pay for it this month so that he can already try and get on the way to get enrolled into Broward College. Financially, though, he has no money in the bank, no property. He lives with his aunt who lives in Fort Lauderdale. He's been living with his aunt for the past 2 months. Judge, he has no sort of financial resources. What he's asking you is if you would consider straight pretrial with electronic monitoring, and he would be residing with his aunt.
What was the prior again, Mr.
2011 robbery with a firearm.
And what was it? He was
I believe he
YO'd
pled YO'd and went to a level 10 program probation.
All right. Mr. Romero, I'm going to respectfully decline your request.
Okay.
Count 1 will be set at $1,000. And count 2, I'll set at $5,000.
Thank you, Judge.
You're very welcome, sir. Good luck to you. And I'm going to order, sorry. Mr. Parker, I'm going to order that you have no victim contact whatsoever with the property of Kushai LLC. You cannot go back to that property. You cannot go back anywhere near with the to any of the people that are in that property as well.
Yes, ma'am.
All right, thank you.
Yes, ma'am. Thank you.
Mark
Mark?
Ventule.
Mark Ventile? Oh, I've been advised he bonded.
Oh, very good. All right.
Jarrell Hayward?
Gerald Hayward.
He's coming up.
All right, Mr. Upsala, would you like to be heard on any probable cause arguments? All right, Mr. Hayward, I find probable cause for count 1, which is burglary of an occupied dwelling unarmed. I find probable cause for count 2, which is grand theft, 3rd degree, dwelling of a property. And I find probable cause for count 3, which is tampering with or fabricating physical evidence. Count 1, Mr. Linder.
Your Honor, I'm going to be asking for a $25,000 bond on 1. I have no objection to the convenience bonds on 2 and 3 being left alone. The reason for this, first off, Your Honor, Mr. Hayward is currently out on release for charges of burglary of a conveyance and grand theft. Whether or not to revoke those bonds, I'll leave to the court sua sponte. 2013, Mr. Hayward was convicted of attempted burglary of a dwelling, 2 counts, sentenced to 39-month state prison, and he was just released August 11th of last year. Additionally, 2012, robbery by sudden snatching. He violated probation and was sentenced to 39-month state prison. 2011, burglary of a dwelling, violated probation, 39-month state prison. Loitering and prowling, 2012.
Mr. Romero.
Judge, in speaking with Mr. Hayward, he's been residing in South Florida his whole life. He is 25 years old. Right now he's unemployed, but he's looking for work. He was previously working in landscaping, making approximately $10 an hour. He has no money in the bank, no property. We'd ask you to set a reasonable bond as to count 1.
And, Your Honor, I apologize. I don't remember if I said it or not, but I'm also going to be asking, should he be eligible for release, pretrial release with a GPS monitor?
All right, Mr. Hayward, you apparently have a pending case where the state is not seeking right now for that pretrial condition to be revoked, any bond that you have placed or any pretrial conditions to be revoked. I, however, am not going to sua sponte revoke that pretrial condition, but it's only a matter of time. But in light of that, and in light of the priors as well, I'm going to set count 1's bond at $24,000. That is correct. And if he is able to, for a total of 30 between all 3 counts. Count 2, I'm going to leave at $5,000, and count 3, I'm going to leave it at $1,000. And if he is able to post bond, then I'll order that he put on Alma on the electronic monitoring. Thank you very much.
Thank you.
David Corbin. Mr. Corbin, welcome, sir. You are charged with grand theft. Any probable cause argument? All right, Mr. Corbin, I do find probable cause for the charge of grand theft. And any arguments as to Mr. Linder?
One moment, Your Honor. Your Honor, I have no objection to the $1,000 bond.
Any problems?
Judge, I apologize, Mr. Corbin. And speaking of Mr. Corbin, he's been residing in South Florida his whole life. He does work. He has nothing full time, but he works on weekends and landscaping. Whenever he can get a job, he's more than willing to work. But unfortunately, at this time, they'll only employ him on weekends. He lives in Fort Lauderdale. Your Honor, he has no money, no property. We'd be asking you to consider pretrial release as to Mr. Corbin.
Does he have any priors, Mr. Linder?
Oh, yes, Your Honor. His priors include 2007 DWS habitual offender, '05 felony possession of marijuana, DWS habitual offender, 18-month state prison, possession of cocaine, '02 18-month state prison, purchase of marijuana, '01 with a VOP, 18-month state prison, '98 possession of firearm by convicted felon, possession of a short barrel firearm, 36-month state prison as a habitual offender, '97 possession of marijuana with intent to sell or deliver with a VOP, 36 months, '97 felony possession of marijuana with a VOP, 36 months, '97 possession of cocaine resisting without violence with a VOP, 36 months, possession of cocaine, '94 13 months, possession of cocaine, '92 30 months, grand theft auto, '92 with a VOP, 30 months, possession of cocaine, '91 with a VOP, 30-month state prison. End of record.
Judge, from what I heard, he does have significant priors, but nothing recent. I believe the last one, I think, Mr. Lender, was in 2008. I'd ask you to consider pretrial.
No, I'm going to deny the request for pretrial, and I'll leave the bond at $1,000.
Thank you, Judge.
You're welcome. Good luck to you, Mr. Corbin. Luis Medina?
Mr. Luis Medina is here present, Judge.
All right, Mr. Medina, you are being held on 2 counts of
Oh, he
violation.
declined to serve as public defender.
All right, Mr. Medina, you're being held on 2 counts of violation of community control, one in case number 1500360 CF10A. You're being held no bond on that. I find probable cause for that warrant since it was signed already by the judge. And count 2 is a violation of community control on 12018 or 13039 CF10A. You're being held no bond on that as well. I find probable cause for that. The good thing, sir, is that you're going to go see your division judge on the 11th of January. Good luck to you, sir. Thank you.
Thank you.
Javier Alvarez?
We don't get why. How's that coming up?
Mr. Upsall? All right, Mr. Alvarez, I find probable cause for count 1, which is driving while license suspended. Count 2 is a capias on a misdemeanor for 160037006 MM48, wherein the bond was set at $200 by that division judge. You have a hearing with that division judge on January 20, 2017. As to count 1, the bond is set right now at $750. I'm not inclined to change it unless I get information otherwise.
I'm not asking for any modification, Judge.
All right, Mr. Romero?
Not at this time, Judge.
All right, so the bond remains at $750, and the bond on 2 is at $200, seeing as how it's
One to the clerk and one to the PD,
Ronald
please.
Salomon?
Mr. Solomon, come on up, please.
That's for
All
the
right, Mr.
perfection.
Solomon, you're being held on
For the-
the violation of community control for case number 1000204 CF10A. That warrant was signed by the division judge for no bond. I can't disturb that. However, the good news is that you're going to go see your judge, your division judge, on the 11th of January. All right, good luck to you, sir. Take care.
Thank you.
This is on the...
This is for the perfection. No, that's for the perfection in the next case. Yes.
Well, no.
Yes.
The other two are more grout.
Calvin Emmanuel Whitting,
I've been advised he's a medical reset, Judge.
again.
Yes, Judge.
Touchstone. Next, whoever Touchstone.
All right.
Cologne, you're right after him.
James Touchstone.
North
Broward.
Trail.
Broward.
Yes, ma'am.
I don't have any more
All
paperwork.
right, how are you, Mr. Touchstone?
I'm doing well, ma'am.
All right, Mr. Touchstone, you're charged with grand theft auto. Mr. Afzal?
Judge, can I briefly go sidebar?
Sure. Just give us a second, Mr. Touchstone. Don't go anywhere,
Yes,
okay?
ma'am.
All right.
Yes, ma'am.
All right, Mr. Touchstone, where do you live nowadays? Are
ma'am.
you still in Fort Pierce?
Huh? No, I'm not, ma'am.
All right, you're living here in Fort Lauderdale?
Hollywood with my aunt.
Okay. All right, here's what we're gonna do, Mr. Touchstone. I'm gonna order that he be, an evaluation. And yeah, I figured, I mean, but as far as his, can I order an evaluation for mental health? All right,
No.
I'm gonna order an evaluation for that. And where does your aunt live?
2341 Hood Street, ma'am, Hollywood, Florida, 33020.
And what's her name?
Her name is Natty Young, ma'am. My mom's older sister.
Okay. And how long have you been staying with her?
About a year, ma'am. And my aunt been working for Memorial Hospital for 29 years. She's in retirement from a nurse.
All right, here's what I'm gonna do. I'm gonna order that if pretrial is able to verify that address and that information. Do you have her phone number, sir?
Yes, it's 954-922-4494, ma'am.
All right, pretrial, did you get all the rest of the information?
The next case in the docket.
You gotta say it again.
What's the next case in the docket?
The number is 954.
922-4494.
And what's her name again?
Natty Young, NETTIEYOUNG.
Okay, and what's the address again?
2341 Hood Street, HOOD Street, Hollywood, Florida, 33020.
Okay, so here's what I'm gonna do. I'm gonna leave the bond at $1,000, or upon verification of the address, I'm gonna order pretrial, and I'm gonna order with just the standard supervision. All right?
Yes, ma'am.
Oh, if he stays in custody, then I'll order a mental health evaluation. All right, Mr. Touchstone, good luck to you. Feel better, okay?
Thank you.
You're welcome, sir.
Come get you. Come on, Mr. Clone. Yeah, go back in the cell. She'll be here to get you in a few minutes. Come on, Mr. Clone. Have a stand on the X.
All right, is this Mr. Emmanuel Colon?
Yes, ma'am.
All right, how are you, sir?
I'm okay.
All right, Mr. Colon, you're charged with 3 counts. Count 1 is a violation of probation on a felony case, 150039160F10A, that you're being held no bond on that. I can't disturb that. Count 2 is a capias on the same felony case. You're being held no bond on that. I can't disturb that either. And count 3 is a capias on the same felony case. You're being held no bond on that. I can't disturb that either. So hopefully you'll be seeing your division judge as soon as possible. All right, sir? Oh, you're gonna see the division judge on the 12th of January, okay?
Okay.
All right, take care, sir. All right, I think that,
I mean, perfection.
Mr. Daniel Santiago Hernandez. Where's he? Me? Oh, there he is.
Your Honor, my understanding, the issue the court had, an argument was raised. The evidence linking him to the burglary was a credit card found in the car that had his fingerprint on it. An argument was made that, well, the fingerprint could have been left on the credit card at any time. What I provided, Your Honor, is supplemental reports, but specifically a sworn statement taken from the victim where she informed the officer that, and I highlighted on page 2, she was shown a photograph of Mr. Santiago Hernandez, and she under oath said she's never seen him before, she's never made any contact with him before. I think that is relevant now because the argument can be made, well, he could have handled her credit card in a retail situation, but if she's never seen him before, if she's never had any contact with him before, then there is probable cause that the only way his fingerprint would have been left on that credit card is if he entered that car at the time of the burglary, where the credit card was left behind and his fingerprint was on it.
Mr. Afzal? All right. I find probable cause as to count 5.
And, Your Honor, as far as bond, he's currently being held on $20,100 bond, $15,000 on an ag assault, $5,000 on a burglary conveyance. This is another burglary conveyance. I would just ask for the same $5,000 bond and no victim contact.
All right, any objection?
Sorry, Judge, I didn't hear you.
Any objection to setting the same bond of $5,000 to the previous burglary?
I mean, financially, he's indigent. He's still in custody. He can't possibly afford any sort of bond, Judge, so.
All right, I'll set it at, consistent with the prior charge, I'll set it at $5,000.
$5,000.
No victim contact, as he's previously been instructed.
Thank you, Judge.
Thank you very much, sir. Good luck to you. All right, so that concludes the morning hearings. We're in recess till 1:30, is that right?
Yes, ma'am.
All right, great. So we're off the
Sure,
record.
1 second.